I'm Halle Turner, and I'm studying for a Master's of Law by Research in the Law Department here at University of Glasgow. It's concerned with unrepresented litigants in Scotland, which here we call them party litigants. A party litigant is basically someone who is not represented by a lawyer in my research in the civil courts. They're also called a litigant in person in England, or pro se in America, so there's lots of different names, but basically they all mean the same thing, which is somebody who doesn't have a lawyer. I'm looking at how the law treats them, what sort of rights they have as unrepresented litigants, and sort of how the court may or may not assist them, or what sort of statutory obstacles or other sort of obstacles they face in pursuing their cases, and with kind of an emphasis on how that affects their access to justice. Well, my focus is very much in Scotland. We've had very little research in Scotland on this topic, and particularly there's a lot of differences between Scotland and England and Scotland and other jurisdictions, so I think it's really important that we don't necessarily just automatically apply research elsewhere to Scotland. And there is so little known in Scotland about unrepresented litigants, and I think that's kind of the main thing I've taken from my research, is how much we don't know about how things actually work for them, and how little data there is. So the big thing that I would take away is that we just really need a lot more research done, mostly empirical research. We don't even know how many there are, like how many unrepresented litigants there are in the civil courts, because these figures aren't gathered by the Scottish Court Service. So that's a big thing, that we don't know really who's using the system, and so it's hard from there to really judge what their needs are. And that's another area that, ideally, more research is needed on. We kind of make a lot of assumptions about how they can be assisted, but we don't necessarily know very much about how they approach the system, what sort of help they need, and how things can be made smoother for them, and also how we can avoid some of the sort of pitfalls that they may cause, because it is kind of well known that if you have a party litigant in a case, you're often going to see more expense, more delay, just based on their inexperience. So that's another sort of thing that we need to know a little bit more about, how that can be helped along to avoid those sort of problems. To some degree you can carry it over, because some of the sort of things that you see are behaviors you see in party litigants that you can kind of assume, well, people tend to behave the same way. So we have some research in England that shows us that they're hesitant to communicate with the other side's solicitor. They tend to do more things out of court and not necessarily in court, by sort of lodging documents and things, and sort of struggle more when they're in court. I think those are things that you can apply to Scotland, or you can sort of transfer over. But then, because our procedures are so different here, our system is different, it is quite distinct from the English courts, we do need to also know more about the problems that are sort of unique to Scotland. And there's also been the research that they've done about how people approach sort of civil justice issues. There are differences in the Scottish sort of approach to civil justice problems from the English approach. They're actually less likely in Scotland to identify that they have a problem that could be sort of taken to the courts and sorted. So those kind of identify needs that are particular to Scotland that we could be looking at. It's not necessarily massively different from other systems, though it does have its own unique procedures. But the way that you would really characterize the Scottish legal system is it's very focused on written pleadings. It's very focused on what's called relevance, which means that you need to stick to your pleadings. You can't introduce evidence or sort of arguments in law that you haven't sort of introduced in your pleadings. And it's also very adversarial, which in that context really means that parties have to bring their case to the court. The court doesn't necessarily go on a sort of fact-finding mission. And that sort of, you can compare that to like a more inquisitorial system. And in that sort of system, the judge will maybe ask more questions and sort of try to draw the case out a lot more than we do in Scotland. So party litigants in Scotland, I think, run into a particular problem because they don't understand the nature of the system, and they think that if they go to court and they say, these are the facts, this is what's happened, so, I've been done some sort of wrong, that the court can take from that what their case should be and give them some sort of remedy. But it's not really how it works. They need to say, this is what's happened, this is my case in law, this is how I fulfilled this legal test, in order for them to be successful in their case. And so it's quite possible that you may even have a valid cause of action, but if you don't communicate it correctly, there's a chance that you're not going to be successful. And that's something I think a lot of lay people looking at the system from the outside, they don't necessarily realize going into it. and so they don't know what's expected of them. In many types of civil action, you can get legal aid to hire a lawyer, basically. They don't have sort of duty solicitors, but you can get basically help funding a solicitor. That's another really interesting difference between Scotland and England right now, is we still have a relatively robust system for legal aid in Scotland, and there certainly are people that sort of fall through the cracks, but legal aid is still available in a lot of cases, whereas in England they've basically done away with it in many kind of actions, including family actions. So we're able right now to sort of watch from Scotland what's happening in England, because they're seeing party litigants just flooding their courts. And so we might be able to learn quite a bit about how they deal with it, because their system is similar enough to ours that, they're having a problem now where they're saying that basically they're starting to have more party litigants in family courts than represented people. So that kind of really makes you start to have to ask the question, do you need to sort of change the system entirely if the users are mostly party litigants instead of solicitors? So I think there's going to be quite a lot to be learned watching them for now, but we're quite lucky in Scotland for now that we still have quite a strong legal aid system. I think there is definitely a degree of sort of back and forth, because we can kind of learn from what they did. It was kind of they may be able to learn from, as we're sort of reforming our civil courts now, certainly they'll be able to possibly learn something from us once that takes effect. You see quite a lot of party litigants in really all types of actions, in all types of civil actions. You do run into particular problems in certain areas, like family actions can be particularly difficult when you have party litigants involved, because obviously there's a high level of emotion involved, and you may have somebody sort of needing to question a witness who's maybe their ex-partner, and obviously things can get quite emotional, and that's something that comes up quite often in sort of cases involving party litigants, when they have to question witnesses, or just kind of keeping that emotional element out of it. My research right now is focused on the legal side of things, so it's looking sort of at like what you call sort of the black letter law, sort of the statutory provisions, the case law, the procedures, the rules, that sort of thing. I'm not doing empirical research at this stage, although I think that's something I may be looking to expand my research into the future. But as of now, just sort of what I'm doing is establishing how the system actually works for party litigants, because it's not always sort of entirely clear. Well, what's really interesting, I think, is viewing the party litigant and how the development of the law at this point. It's been really interesting right now to look at kind of some of the social and societal trends that you're seeing. We're looking more at things like public legal education in Scotland, and what's called legal capability, which basically refers to sort of both public legal education and people's ability to use these skills, such as confidence, communication skills, that sort of thing, decision making, that allows them to actually take their legal problems forward. And alongside that, there's also a sort of sociological trend that's called disintermediation, which basically just means sort of a fancy way of saying DIY. People are more and more wanting to do things for themselves. They're, when you want to solve a problem, you Google it more often than you're necessarily going to want to go to a lawyer. So I think all of that sort of together, I think, is really interesting in terms of that perhaps policymakers are going to have to be looking at more of maybe even of a demand for people to have better access to the courts without a lawyer. That it's not just people who maybe can't afford a lawyer, although that's obviously a very big problem if you can't afford a lawyer. But the other thing is that they may just not want a lawyer. So there's kind of a lot of really interesting things going on in the field just now.